Yeah, my task today is indeed to present to you the recent case law on the Brussels IIa regulation. There we go. There have been 40 judgments by the European Court of Justice on the Brussels IIa regulation. When I counted them, I was surprised myself. That's quite a lot. Obviously, since the beginning, right? Since 1 March 2005, when it entered into force. 2 cases are pending at the moment, one of which Mr. Heger referred to yesterday already, the one about habitual residence. And then there's another one in which there is already an opinion by the Advocate General. So I'll also use those cases to point to some sort of legal issues open at the moment that deserve our attention. The regulation, Kirsten has already mentioned, has been recast but is not yet in force, so we're not discussing that yet. So the new regulation, which is called either Brussels IIa recast or Brussels IIb or Brussels II term, or in the French-speaking world, will enter into force on the 1st of August 2022. I have understood that it's the central authorities and the ministries of justice that have really negotiated this long transition period of 3 years to be able to train everybody about the changes. So I think it's in a few years only that ERA will really organize something on that new regulation, at least about the practice of it and about the application of it. The issues that have come up in the judgments by the European Court of Justice are mostly about parental responsibility. There have been a few cases about divorce, but most of them were about parental responsibility. Quite a number about habitual residence, but all of those cases concerned the habitual residence of children. Now, for the first time, we're really facing a case of the habitual residence of adults. The prorogation of jurisdiction, the idea of choosing jurisdiction, how long does this choice of jurisdiction stay valid, when is it valid, and so on. The chopped up jurisdiction, Véronique Chavot referred to that yesterday, and I'll also come back to it in my presentation, that you have the jurisdiction rules for divorce, you have the jurisdiction rules for parental responsibility, and the rules for maintenance. And they are separate worlds. In the private international law terminology, they are characterized or qualified differently, which chops up your jurisdiction and your applicable law. There have been cases about transferal. When one court says, well, actually a court in another country is better placed to hear this case, that also only exists in parental responsibility cases, not in divorce cases. And there have been quite a number of cases on child abduction. 2 of the cases that were at the European Court of Justice on child abduction also subsequently went to the European Court of Human Rights. So you've had the same case going to both those courts. One of them was very recent. So I'll discuss the recent one as I'm restricting the presentation to the judgments of the past year. You should come to ERA every year, and then you're completely updated, you see. So just a brief table of the cases on Brussels IIa. You see that the big years were 2015 and 2018. For 2020, we don't have a judgment yet, but there might still be one, right? Because there are these 2 pending ones. One of which there is already an opinion. All right, so let's start with this one then. I really enjoyed your remark about Romania being a favorite forum for Italians, because that's exactly what happened here. Well, these were Romanian people living in Italy, but then going back to Romania to get divorced there. So this is an order, which means that the Court of Justice ruled without opinion by the Advocate General, and it basically means that the court considers these questions not as difficult or really clarified already. Okay, so I'll try to show that on the basis of the law, yes, that's true, but underlying there are some policy issues that do raise a number of questions to me at least. So we have 2 Romanian nationals, OF and PG, that were married in Romania. The child was born in Romania, but soon after the child was born, they moved to Italy. They lived there for a long time. When the child was 11 years old, so after 12 years of marriage, they had a de facto separation. The Tribunale di Aoste pronounced that factual separation and gave the exclusive custody of the child to the mother. And the father had access rights, and he had to pay maintenance for the child. All right, so they carried on living like that, and then another 6 years later, so when the child was 17, the father went to the Romanian courts to ask a divorce there. Now, there was no written agreement on the jurisdiction, but remember, both parties are Romanian nationals. So let's turn to the jurisdiction grounds of the Brussels IIa regulation. They're in Article 3. There's a whole hierarchy of them. And there are a whole broad range of possibilities. The habitual residence of the defendant, the habitual residence of the claimant if he or she has lived there for 1 year or 6 months plus nationality. You have a whole range there. And then you also have the possibility of the common nationality. So what happened here was again quite similar to the previous case, that the Romanian court is feeling a bit sort of cornered between EU law and its own law. Because under Romanian civil law, as soon as a divorce is applied for, then the court of its own motion must also consider the parental responsibility and the maintenance claim, because there is a minor child. Okay, the child here was 17, so the court says, okay, you have a minor child, I also have to look at parental responsibility and maintenance. From a policy point of view, I think it's a good rule in the civil code. Okay, we need to take care of the children, we need to, make sure that the court also rules on this matter. However, it was clear under EU law that they didn't have jurisdiction, because the child has lived in Italy for 16 of its 17 years. The child probably doesn't, the child has never lived in Romania, probably has family there, sure, but it was very clear that the Romanian courts do not have jurisdiction. Same question for maintenance. We looked at the maintenance regulation quite extensively yesterday. There's no jurisdiction for maintenance of the child. So the Romanian court, you see, kind of feels uncomfortable with this and then asks the Court of Justice, okay, so must this jurisdiction on the basis of nationality be accepted? Must there be an agreement? Or is it somehow maybe lower in the hierarchy of jurisdictional grounds, that first you have to go to the Court of the Common Habitual Residence, and only after that there's the possibility of going to the Court of the Common Nationality? No, said the European Court of Justice, that's clear in the wording of the regulation. These are a number of alternatives. You can choose any of the alternatives. That's also very clear. After the Haddadi case, the court said, okay, you don't have any reason to discuss that matter. But then the court said, well, maybe then, maybe there was a tacit agreement for the jurisdiction on the parental responsibility. Because as we know if the parties agree to jurisdiction, the court can also take jurisdiction. But, in this case, there was no explicit agreement. The mother did not enter an appearance in the proceedings in Romania. She was served with proceedings, but she just didn't come. So it's a bit difficult to then say, she agreed with the jurisdiction. The court said, well, agreeing to the jurisdiction must either be expressed or unequivocal, so it must be clear. Here, not really clear that she agreed to that. So you can see that the Romanian court kind of wants to get rid of the divorce case or draw everything into the case, because for them, it's one thing. If I understand correctly, under Romanian civil law, they see divorce or divorce with children. And if it's in the box divorce where there are children, we have to look at parental responsibility and maintenance. So the court is clear in saying, okay, fine, you have jurisdiction on the divorce, but not on the parental responsibility and not on the maintenance. Easy case on the law. However, you see here a tension between EU law and national law, as I say, because of this policy that the Romanian courts want to forward. The Court of Justice responds, well, you have to have mutual trust. Those issues of parental responsibility and maintenance, they've been dealt with in Italy. And if they've insufficiently been dealt with, well, the parties should go to the Italian court. What I wonder is whether it would have been different if the mother had entered an appearance, and by entering an appearance in Romania, knowing Romanian civil law, could be considered as tacitly accepting the jurisdiction for the parental responsibility and maintenance, okay? Because she knows that coming to Romania for my divorce means also drawing in these other elements. So if I don't agree with having those other elements drawn in, I must explicitly contest the jurisdiction on parental responsibility and maintenance. That was not at issue here because she didn't enter an appearance, but I'm wondering whether that would have made a difference. Then the tension, I think, is really about when is something considered to be part of the proceedings or not, you know, how the parties see it or how the court sees it. Okay, and I'll maybe just refer you to this paragraph to explain what I mean. The Court of Justice says in paragraph 37 that the fact that the couple seeking dissolution of their marriage have a minor child is irrelevant for purposes of jurisdiction. Now, if you read that in isolation, on the one hand you say, well, legally speaking, yes, that's exactly what Brussels IIa says. On the other hand, policy-wise, I think it seems a bit strange, saying, well, it's irrelevant that you have children. But then what's supposed to be the answer here is the mutual trust argument. So just an order by the court, so not considered to be a very difficult on the law case, but I thought that was quite an interesting one. The next one is very interesting. This one Staatsanwalt Heilbronn versus ZW. This is the case where we don't have a judgment yet. We only have an opinion by the Advocate General, and I see the German Berliners smiling already. So here we had two Romanian citizens. I don't know why Romania is so prevalent today. But this time they were not living in Italy. They were living, the child was born in Romania, but the mother and the child moved to Germany. With the consent of the father, so the mother was with the child in Germany, no problem, the father was in Romania. But then the child was placed in a welfare facility under this system of Ergänzungspflegschaft. So there was an Ergänzungspfleger who actually had partially the parental authority over the child. It's that Ergänzungspfleger that can decide where the child will live. Okay, and the Ergänzungspfleger says, well, this child has to live in the institution because of many behavioral problems. Then, at a certain point, the child went back to the mother's home in Germany, and the father then took the child back to Romania with the mother's consent. So, legally speaking, we have a child abduction by both parents to Romania, because child abduction means that it is in contradiction to the parental authority, and the parental authority here belongs to the, thank you, the Ergänzungspfleger. I really practiced this word. So, yeah, legally speaking, there's a child abduction. So what do the German authorities do? They say, well, under our law, child abduction is an offense. It's a criminal offense, so criminal proceedings against both the father and the mother, because she was complicit. She helped him to take the child. She then said that this criminal prosecution of hers is contrary to EU law. Why contrary to EU law? Well, because we have free movement in the EU. And as a Romanian citizen, she can go and live in Germany, and she has the right to go back to Romania, and she should not be hampered in this free movement. Of course, she then refers to the Treaty on the Functioning of the European Union and the Citizens Directive. That's Directive 2004 of 38 of 2004. Of course, there are exceptions there of public policy, but the Advocate General actually says here, and I'm going to the next slide, again, mutual trust. The Advocate General starts by saying this is a restriction to EU law. Okay, that's clear. It is a restriction to EU law. If you're being prosecuted for going to a different country, that is a restriction. The next question is it proportional and is it necessary? Now, there's a little mistake on the slide. There must be a question mark after proportional. Okay, so the Advocate General said, is this proportional question mark, let's look into it. And the Advocate General said, well, this is not necessary. This distinction that German law makes is not necessary. This distinction being that if a child is abducted without force from the north of Germany to Heilbronn, then that would not be a criminal offense. It would only be a criminal offense if they were forced. Okay, if they were forced to take the child, if I understand that correctly. However, it's different if you take the child to another country. And if you take the child to another country, German law does not distinguish between whether that other country is an EU country or outside the EU, right? So this is a criminal offense. The Advocate General says, well, if the child is abducted to an EU country, you have the Brussels IIa regulation. You have mutual trust. You can go and get the child there because you have automatic enforcement. So you should consider this as rather similar to the German situation, and you cannot just say, well, abducting the child to Romania is exactly the same, legally speaking, as abducting the child to Argentina. I was very surprised when I read this, and judged by your faces, at least of the German Berliner delegation here, you are as well. I would be very surprised if the Court of Justice follows this. This is mutual trust, but it is really going quite far, this mutual trust. Because normally in child abduction practice, criminal proceedings is really sort of the last resort. Okay, we're trying to solve these issues through civil law, but if nothing else works, we have this criminal law stick really to solve the issue. So let's see what the Court of Justice says about this. And maybe you want to say your opinions after the presentation. The next case does not concern Romania. This is the case that is still pending. It is a case of an Irish woman and a French national man who are married and who live, well, the family lives in Ireland. They have 3 children there. The father works in Paris, and when he's not working, so weekends and holidays, he spends with his family in in Ireland. Ireland, yeah. So the question is, the question the Parisian court asks is it possible to have 2 habitual residences? A very interesting case indeed, because up until now the court has said, or at least implied, that there's only one habitual residence, because we've seen in the case law we have firstly the case A, which concerned children, but school-going children, and which listed a number of factors. And if you look at that case, and then later the Mercredi case, C case, the OQ case, the court keeps on looking at those factors, and you have to apply those factors to find the habitual residence, not one of the habitual residences. So there's always been this idea that there's only one habitual residence. Also in the succession regulation, that's the idea, there's only one habitual residence, okay? Now, there has been a lot of research done by the EU FUMS project. I don't know whether you know that project. It was funded by, or is funded by the European Commission. They're now just finalizing the EU FUMS 2 project, but on the EU FUMS 1 project, they collected a whole lot of case law. And that case law is available on a database which is managed by the University of Milan. Fantastic database, because it has English summaries of, I don't know, thousands of cases. And the English summaries, especially in these habitual residence cases, are useful because you can see the factors that the court considered, okay? We're not looking at super technical legal details. We're looking at factors that the court considered, and you can translate them. Very useful. And there I found that the Czech court and the Slovak courts, various courts actually, found that dual habitual residence for children is possible. There's even a judgment by the Slovakian Supreme Court that states that dual habitual residence of children is possible. That in that case, the children went to school in different countries. Now, hopefully that's not often the case, but that was the case there. So the court said, yes, the children have 2 habitual residences. In the Greek and Italian case, the court said, no, we have to find the habitual residence. In the Italian case, it was a question of whether the children lived in Germany or Italy. The Italian court then said, well, we can't figure this out. We don't know where the child has their habitual residence. So what we'll do, the court says, is we'll say, we don't know what the habitual residence is of the children. What do you do if you don't know what the habitual residence is? Then you look at Article 13 of the Brussels IIa regulation, which says, well, if the habitual residence of the child cannot be established, it is the court where the children are present that has jurisdiction. So that's how the Italian court solved the issue. However, we don't have an Article 13 for adults, of course. For adults, we have to know where they have their habitual residence. So here, it would be interesting to see whether the court says that dual habitual residence is possible. It would also be interesting to see what the court then says should be done. So if there are dual habitual residence, is it up to the adult himself or herself to choose which habitual residence will I rely on for my case, as they did in Haddadi? With dual nationality, the parties can choose which court they go to. Or will they say, no, we stick to one habitual residence, and if so, these are the factors, okay? Because I think that the factors for children, some of them you can obviously transfer to adults, but it's different for adults because obviously they don't go to school, but there's also, I think, a larger subjective element. A child cannot decide of its own, I'm going to now go and live in Italy. The child is dependent on decisions by the parents, while adults make decisions for themselves. So I think there's a bigger subjective element for adults. There again, there's a lot of case law. I've also analysed that case law, but I can't go into all of that now. Yesterday evening, we discussed the issue of habitual residence in times of COVID, right, where children are stuck for 3 months somewhere. They don't. One parent doesn't really want them to live there, but they can't leave. So maybe if you have issues or examples of that, we can discuss that also in the session just now, if I don't speak too long. The European Court of Human Rights then. I'll refer to these cases briefly. There have been 80 cases by the European Court of Human Rights on child abduction only. Okay, these are only the child abduction cases. 2 cases, as I've said already, went from the European Court of Justice to, well, not from, but went both to the European Court of Justice and the European Court of Human Rights. The issues before the European Court of Human Rights were Articles 8 and 6 of the Convention. 8 concerns family life. So there they also looked at the best interests of the child, hearing the child. And then Article 6, that's the right to a fair trial article. There they looked at the duration. Very often the issue with child abduction cases is that they take too long. The first case was a case against Latvia. They were a Latvian mother and a Norwegian father. The couple had a child in Latvia. They moved to Norway when the child was very small. However, the mother kept strong ties with Latvia. She had child support in Latvia. She had unemployment benefit. She had her family doctor in Latvia. She was never employed in Norway. She did not have unemployment benefits there. So she, you can sort of say that her social net was rather in Latvia than in Norway, but she lived in Norway. The family lived in Norway. The child went to kindergarten there. She then, as so often happens, goes on holiday to Latvia for 2 weeks and never returns. The Latvian court ruled that the child has to return to Norway. She alleged that there was violence by the father against her. She also alleged violence against the daughter, but she did not prove that. Also, the court considered these elements, and that was what is very good, I think, about this judgment by the European Court of Human Rights, is the court says, okay, we are not there to put ourselves in the place of the national judges. Where the habitual residence is, we can't decide on that. That's the national judge. All these, whether there's a grave risk, that's not for us to decide. We can only check whether the national courts did all the steps that they should do. And the judgment lists a whole sort of list of things that the National Court did do. It did look at all these certificates and the fact that the mother never went to the authorities in Norway, neither in civil proceedings nor in criminal proceedings. She never said anything about the domestic violence there. So the court really lists everything that the National Court considered and then comes to the conclusion there's been no violation of Article 8, okay, because the National Court made the correct assessment. On Article 6, the court says, well, here there was a procedural issue. The mother had a lawyer in first instance. Then in second instance, she discharged the lawyer. She said, I'm going to represent myself. The court in Latvia apparently works with an e-filing system, and the mother was not herself notified of the submissions by the father. So these notifications were sent by her lawyer, who was not representing her anymore, and was not sent to herself. That the European Court of Human Rights said was a violation. She should have had access to that entire electronic file. That's a procedural, I think, mistake that was made in Latvia. So and there the court did find a violation. I'm going to skip this case and go to the Reno one briefly to finalize this. The Reno case is the case that also went to the European Court of Justice. Very acrimonious case. There were, over a period of 2 years, there were 30 decisions by the Latvian courts, by the German courts, by the Court of Justice, then back to the Latvian courts, and it just carried on and on and on. And the case went to the media in... I'm sorry, this is Lithuania. It's not Latvia, it's Lithuania. So in Lithuania, the case got a lot of media attention. There was a 35,000 citizens signed a petition for this child. The Minister of Justice said, but I'll help you, I'll give financial aid. And it just went on and on. So the father brought these proceedings. And what is interesting about the case, just the elements of EU law that I want to highlight, is that the Court of Justice refers to the Habitual case, which was a Latvian case, where